Hello there, my YouTube family. It is your Supreme Judge, and I'm back with another video. And this time, we'll be talking about Tiger Woods and all his legal problems. Remember, like, subscribe, and share if you want to see how I would defend him or how I would prosecute him in a case.
Greg, thank you for being here.
Lori, it's good to be here.
So Tiger Woods gets into a crash. He's charged with DUI. So either he was under the influence or he wasn't. Simple, right? Tell us about what makes this case a little more complicated.
Well, in this case, it's a little more complicated because Tiger Woods agreed to take a breath test. The breathalyzer came back triple zeros, showing no alcohol in his body, but the issue is whether he was impaired. There were statements regarding hydrocodone, Vicodin. Law enforcement found 2 hydrocodone pills in his pocket.
And they were loose in his pocket. Does that make a difference?
Well, it does. I mean, that's actually a crime under Tennessee law to have prescription drugs that are outside the prescription bottle. But again, let's kind of break this down. You have to have reasonable suspicion to stop someone and then probable cause to make an arrest. In this situation, Tiger Woods was driving his Range Rover at a rapid rate of speed in Jupiter, Florida. A truck hauling a trailer slowed in front of him. He clips the trailer, rolls the truck, has to crawl out the window, and then when law enforcement arrives, all the usual symptoms. He was sluggish. He had red and bloodshot eyes. He had slurred speech. So, you know, a lot of red flags. But what's interesting, law enforcement continued their investigation.
Should he have refused, could he have refused the field sobriety test for one?
I think he could have, because under the gold standard, the National Highway Traffic Safety Administration, if you've had a serious collision, they're not supposed to give you field sobriety test. The one-leg stand, the 9-step heel to toe, pivot, and turn. So he would have been well within his rights not to take the field sobriety test. Curious as to whether, if he was not free to leave from the very beginning, any statements could be suppressed because he wasn't Mirandized. So, you know, it's interesting whether those field sobriety tests, whether one, they should have been given. Second, if they were given, whether they would be admissible. And
what about the urinalysis? He said no to that.
That was a smart play by Tiger. Even though he agreed to the blood, he very cagily did not agree to the urinalysis because that would have shown opioids in his system. So that was very smart. Also, he let law enforcement know that he'd had over 20 surgeries on his leg, 7 surgeries on his back. Another reason why field sobriety tests shouldn't have been given. But you know, Tiger Woods entered a plea of not guilty, but he did what most smart clients and most smart lawyers tell you to do when you have bad facts. He didn't want to go to jail for 48 hours, lose his license to litter pickup. He's going to treatment. So he's had a history of issues with driving, arrest, but very unfortunate. But it's going to be interesting to see whether the evidence that we're hearing about in media reports actually sticks in a courtroom.
Now, that was a very good explanation done by the news. And I also do want to make it very clear, I do not own the news clip. I'm using it under Freedom of Information Act and also under the copyright claim as well. So yes, that was a really good breakdown of just the situation he was in, that he's currently facing. And as the attorney did point out, he does have like some prior issues with driving that I'll, you know, bring up later in this video. But the main point is I'm gonna go over a hypothetical and what I would do in this case as a defense attorney and then as a prosecutor if I was prosecuting the case. So let's break down the legal analysis of just what's going on with Tiger Woods' current legal situation. Now, you guys know I like to give you some pretext before I give you the full context. So let's just go a rundown of what all of Tiger Woods' legal troubles that he's faced in the past up until now. Now, Tiger Woods, for all his credit, is a renowned athlete with a very accomplished sports history. Honestly, I really can't stand to see someone of such high potential who've made it to this powerful point in life where they have these millions of dollars and status, wide renown name. It really is sad to see someone go through these type of legal matters, but at the end of the day, we're all people. We all are human, and we all go through rough patches in life. It's pretty common for people to go up and down, and some people, just go through things and they unfortunately turn to the wrong sources for their source of comfort, for lack of better word. Now, if I was a criminal defense attorney in his case, what I would definitely use is the family man strategy. And I'm going to get in detail is how that strategy would work in court. Now, first things first, I do want to say many people are mistaken in the sense that they think that like a legal case would include everything someone previously did, when in fact, in the United States, basic legal doctrine that follows for most cases, except in special circumstances, is that anything you did prior to, outside of this specific court case or specific charges that you're battling against, would be completely separate. So say for instance, if you had prior criminal history or multiple cases going on, the vast majority of the times that will all be separate from what you're being charged with or what's specifically going on at the present moment. Alright, court is in session. Let's begin. Now, in this particular case, featuring Tiger Woods versus the state, the way I would handle this if I was a defense attorney on this case would, as I mentioned earlier, with the family man strategy, which is my own personal strategy that I came up with, but it is based off the legal doctrine called character-based mitigation strategies, where you focus on the character of the person. Now, I will say this is somewhat a little bit harder with Tiger Woods because, as I did mention earlier in the video and in the news clip as well, which I don't own, he has had some prior legal issues featuring him in a vehicle. So just to bring those up and go over those just a little bit. So in 2017, he got a DUI arrest in Florida. He was arrested on May 29, 2017. He was found asleep in the vehicle, but the impairment was linked to, again, medication. So though he was charged with a DUI, the outcome was he did plead guilty. He got 12 months probation and a small fine, along with some community service in that particular case. So I do want to point out something that is very useful for a defense attorney to use in this case. It was to always point out that in none of his cases featuring him in a car, he was a harm to anyone else. He didn't hurt anyone else, and he didn't cause massive property damage like we've seen in certain other cases. Me focusing on his character will not be the only thing that could potentially save him in cases like this. Me also presenting to the court about, as I mentioned earlier, about not harming anyone else in any accident or being a danger to society or being drunk. It's important to note as well that in this current case or in any prior one, he wasn't under the influence of alcohol. It was very much featuring whatever medications he is currently taking. A big important thing with legal doctrine, and especially when you're in a high-profile case such as this one, you need to combat each and everything the prosecutor is trying to lay out in their case that they're trying to prosecute against someone. You need to be able to combat and say, my client either didn't break this, or this was misconstrued, or the evidence is lacking for you to prosecute on this ground. So I'm going to present to you in Florida what the law is for driving under a DUI. Now, as an defense attorney, what you want to do is you want to attack that law, especially if this were to go to trial. Now, I'm just being honest with you. If I was a defense attorney, I would try to dead this thing and negotiate as much as possible with either the judge or the prosecutor. I would try to prevent this from going to trial just because I do think this will have a high chance at working before going to trial in any courtroom, where you would be able to maybe negotiate some type of rehabilitation plan, such as community service, or maybe even a temporary suspension, or even maybe the most important thing really is make sure you stave off any jail or prison time, and also as well continue any rehabilitation services, and also making sure you smash and heavily use as your leverage his medical problems and medical issues and the medication he's taking. Maybe have a doctor prescribe a new medication. Maybe bring in some medical professionals, and also have his doctor write a note and bring in the prescription information in order to showcase that under normal circumstances, he's a good person. He doesn't have any issues. It's been a long time since he was in a previous accident, which was in 2017, and smash that it was not under some illegal drugs or alcohol and any other substance abuse. This is medically prescribed medication, and it was simply the medication's fault, and it was not his personal doing. And if it wasn't for the fact of the medication, this would not have had happened. Now, as I like to point out, each case is different, has its own fiat, and I would love to do more of these cases with you guys, but I do think this has an excellent chance of going either way. If I had to put it on a scale, I want to be about 55% for certain this could go the defense way. Like, the prosecution would have to make a strong case, and I think if the defense can keep out any prior history he had, they have a strong chance of winning. But if prosecution is allowed to bring that in, they could create a scenario where it does seem that he would be more than likely a danger to himself if they don't, for example, suspend his license, charge him with a fine in order to teach him a lesson and not do it again, or even pursue deeper criminal penalties, such as locking him up. But I do think prosecution would have to strongly present a case where this is someone who has some type of addiction, but the defense will be able to strongly rebuttal in the sense that they, can point out no alcohol abuse or any illegal substance abuse, and this was medically given in his prior medical conditions and all the things we know about him being a good person to mitigate some of the public damage and also, court damage prosecution could use. But this was a really good case, and it really got me to thinking how I would defend him. And in the next part of the video, I will go over what I would do as a prosecutor on this case if I wanted to seriously make him face penalties. So please take the time to like, subscribe, and share, and comment. Let me know how you think I did. Let me know if you would argue something different. Let me know how you feel about this case.